You might know this, but in Arizona, domestic violence cases are a little different. And even though they're misdemeanor cases here in our criminal justice system, things happen that are kind of upside down in the domestic violence cases. And today I'm going to be talking about that. First of all, you might want to know kind of what would happen if the victim of a domestic violence case changes her mind and says that she doesn't want to prosecute. It's not going to matter whatsoever. The police will not listen to the victim and drop the case. My name is Darren Woodfork, and I'm an attorney here in Scottsdale, Arizona. I've been practicing law here for 26 years. In the early part of my career, I did a lot of public defender work, and then I did a lot of criminal defense work. Right now, I do a lot of personal injury cases, restore gun rights here, and seal old criminal cases. But I want to talk about, every now and then I'll get a case from a former client involved in a domestic violence situation. It's an assault, the husband and wife get in an altercation, and then the defendant is arrested for assault and a domestic violence charge. And what surprises a lot of people is that it surprises the couple because the victim doesn't want to prosecute like the next day. They want to change their mind and they want to drop the case, and it surprises them that they just can't. In Arizona, in an assault domestic violence case, the state of Arizona is the victim. It's not the person who was in the fight, at the house, whatever. And so the state stands in place of the victim, and therefore the victim can't drop the case if they want to. It's the state's going to go forward. And the prosecutors will decide whether or not they go forward or not. And there's a practice here in Arizona anyway, where a lot of times the prosecutors will not go forward if they don't have a cooperating victim. But they absolutely can go forward if they want to, and if the case is a case where they want to pursue for policy reasons or whatever, they will go forward. And when we're in that situation as defense lawyers, the obvious thing is what we say is, well, you can't prosecute somebody because there's no person with no victim, because there's nobody to confront. There's no cross-examination. And that violates the Sixth Amendment confrontation clause. And there's a ton of case law about this. And every time we're in this situation in court, we argue that this violates the Sixth Amendment confrontation clause. And unfortunately, it's a judge-type ruling, and most of the judges will allow the case to go forward without the victim if there's other evidence of the assault from the day before. And a lot of times, and the police know this too, so the police, when they go out to the scene, they get all the information that they can, all the evidence that they can, so that when they know the next day when the victim changes her mind and doesn't want to prosecute, they can still go forward with all that the investigation or the evidence that they gathered the night before. And so what that usually is that's photos of the injuries, that's recorded statements from the victim, and that's the police report that they write. And then all that stuff comes into evidence in a case with no victim. And again, there's a million objections that we make in court because of that, because the victim's not there. But the judges a lot of times will just let it in and go forward. And then also, like I said, even if the victim doesn't, and I talked about this, I think, in another video about if the victim can recant their statement, if that matters, and it doesn't. And so a lot of times what you'll have is like the victim the next day changes her mind, and so she calls the cops or she calls the prosecutor's office and says she doesn't want the prosecution to go forward against her husband, and then it's too late. And so then even if the victim affirmatively says, I don't want to do this, I don't want to cooperate, it doesn't matter. The state will continue to go forward. And so that's just like the policy thing about it. And so that just kind of like, in my experience anyway, the domestic violence cases are just different in Arizona's criminal justice system. The judges and the prosecutors are just different. They're not as reasonable. They're not as, again, they will just keep going forward on cases. Even if they have a bad case, they'll just keep going forward, keep going forward. And I think, and again, I don't know, I'm just speculating here, but I think it makes them mad when literally every time the police go out to a domestic violence situation, the next day, like clockwork, the victim is going to recant their story, change their mind, and say that they don't want to prosecute. So they just get tired of that. And I think that's why they're such like zealots when it comes to these type of cases. I talked about this in the recanting video where, 30 years ago, police, the whole point of the police taking those portable tape recorders was because they wanted to tape the victim at the scene, get all of her statements when she was scared and frightened and all that, get all that on tape because they knew the next day she was going to change her mind and says that he's a good guy and I don't want to prosecute. So that's what happens in domestic violence cases, assault with domestic violence cases here in Arizona. If you're ever in this situation, you really do need to hire a counsel to help you go through this because it's not as easy as you're just going to ignore it because the victim is not going to cooperate. It doesn't work like that. But anyways, hope they found that interesting. If you have any questions, please leave them in the comments or shoot me an email at DerronW, that's DERRONW @MSN.com. I'd be more than happy to answer any questions that you have. And please like the video and subscribe to the channel. Thanks.